Hey, right, everyone. Just bear with me a sec. Slightly more efficient now this week. Yeah, so welcome, guys. Oh, here comes Karis now, actually. So let's just wait for Karis to get a um, foot in the door or whatever. Hope you guys are doing all right. See, there's a pretty nasty storm heading it our way, or certainly northwest way tonight. So if you're somehow watching this and potentially sleeping out tonight, just go particularly careful. Hey, right, Ginger, how's it going? You right, Dennis? Lynn, nice to have you here. You right, Sabat? And Shannon, yeah, nice. Hi, guys. Thanks for the nice little greeting there. You right, Carol? Karis is just joining the audio right now, so she might just take a moment to get in
Hello.
there. Hey, you right, Karis? We've got no Shannon tonight, so it's just us three. Hope you guys are doing all right out there. It's the most depressing week of the year anyway, and then we've got stuff going on in America and whatever. So hope you guys are keeping your sanity and whatnot. I've got a little bit of gossip, but not much. Just to say that if you do get the local government and social care ombudsman updates every week, which you can do just by going to their homepage and signing up for it, there was a couple of interesting cases this week, which I'll probably do videos about. One was about Oxford, I noticed. Not not kind of particularly unusual, but just kind of standard sort of gatekeeping bits and pieces. We've got about 6 questions to Karis. I've just sent another two that we had last minute. So just yeah, if they're not making sense, they're in your inbox now, but only just. So yeah, and there are three anonymized, so we'll do them first. Then we get into the live chat as we always do, and then we'll come back to the not anonymized questions at the end. On that note, please, guys, if you're asking questions in the live stream chat, just ask the question as if it's about a hypothetical person or just a what if question. What if someone was serving the Section 21 notice? You'll get a better answer actually, and you don't have to put your personal data all over the web, which is probably quite a good thing. Anyway, DC, what else do I need to say? Oh, yeah, it's not legal advice. So we're going to do our best here, but it's obviously not stuff you want to go and rely on. We're just going to hopefully give you some pointers, just that we're going to give you an idea of how it all works and whatever. But yeah, other than that, I think that's it. There was an amazing event I went to yesterday. I mean, there was some really good bits. It was, I don't even know who it's by. It's the University of Southampton, which has got a long history of having some really good stuff. There's a professor there called Nick Maguire, who's very, very good about trauma. And it just says he only said a little bit yesterday, but he kind of really chipped in when people saying, "Oh, we don't know if we want to give people tents if they're rough sleeping because we might be encouraging rough sleeping." And he basically ripped them apart. And there's a bunch of people as well who'd been homeless themselves and were just and there's about 150 housing officers in the audience, and these guys, there's an older guy, a really cool guy called Charlie, very articulate, kind of just talking about basically how homelessness services are traumatizing, and it's just interesting to see how the housing officers weren't able to just hear it. They weren't even able to hear him say it. They were like, "Oh, well, we've got loads of funding issues, and our service is actually really good." And I think all he really wanted was just for them to hear it, just say, actually, guys, you know what? Despite all that, that's all your problems. But just to let you know, it's actually really, really difficult for people to access assistance. So, if you go in a Facebook group we run called Homes as Best Practice and just pretend to be a professional, just say you are. That's all you need to do. I put the link to the video in that group. So, yeah, as I say, it's 2 hours long, but it was just really good. The actual title of the event was like, "Why do people refuse offers of accommodation?" And yeah, a lot of sensible stuff was said within it. So yeah, let's get to the questions. So let me get the thing up and running. Just bear with me whilst I do a few bits here. No, I don't want AI right now. So question one is an interesting one. I think all of them are tonight actually. So let's just get a bit further down. That's annoying me. There we go. Right. Yeah, so and zoom in a bit as well. Cool, right, that should be all right. So if someone complains because the right duty wasn't given at the right time during the homelessness application process, can this be corrected? For example, the council delays in giving relief duty after Section 21 expired, despite having all the information needed in priority, not intentionally homeless, etc. Or does the council need to start the 56-day relief duty anyway before giving the main housing duty, meaning that the time of the delay in giving the right duty is lost and not recoverable? So there's actually a couple of questions in there which are good. So weirdly, and this is one of my actual main criticisms of the Homelessness Reduction Act in general, is that councils are not able, or well, they're advised against issuing a decision accepting the main duty before the relief duty ends. So if you're in priority and not intentionally homeless, the council can't actually tell you that until the end of the 56-day period, which often means people are just absolutely worried sick because they don't know what's going to happen. But that's not council's like that. That's council's following the guidance. The guidance itself is rubbish. So the thing in this situation, which is probably going to be an issue here, is whether the relief duty was accepted when it should have been. And in most cases, the relief duty should start once the Section 21 has expired, as in the day after the Section 21 expires, unless the criteria is unless basically the landlord might keep you on a bit further, and there would be no defence to possession if you went to court. So unless those criteria kick in, the relief duty should start the day after the Section 21 expires, and that's important because it's not until the relief duty ends that in many cases things actually really get moving anyway. So the main duty can't be accepted before the relief duty ends. So that 56-day period, you're just kind of in limbo. They might make an offer of accommodation in that time. If it's a final offer or it's called a final accommodation offer or a final Part 6 offer, you need to accept it. There is no kind of second chance. You can refuse lesser offers of accommodation if it's like really poor quality, if it's supported accommodation or something, but that might then have implications on whether they owe you the main duty. So essentially what then might happen is you end up with a final accommodation offer or final Part 6 offer. I apologise for how much jargon I'm saying right now. If you're interested in this sort of stuff, there's a video on the channel called "Can I Refuse an Offer of Accommodation?" or "When Can I Refuse an Offer of Accommodation?" or something. So I talk a bit more about that in a bit more detail there, probably do a better job of it. So basically, the complaint in this situation is probably that they didn't accept the relief duty when they should have, and that then put a delay to everything else. And so you could complain about that and say, hey, you delayed issuing the relief duty and therefore the main housing duty. And the LGSCO would probably recommend a couple of £100 compensation there, and they'd also get the council to backdate your active date on the housing register by however many days they delayed it by. So backdating the start date on the housing register is one of the things that the LGO often recommend. But other than that, I feel like I've answered the question there. But Will and Karis, have I missed anything, or is there anything else that you would want to add in at this point? I'm getting shakes of the head there. So okay, we're going to assume that's all right. So hopefully that answered the question there. So it's a good question. And next question is, so housing officer told my friend that it's up to the temporary accommodation team where interim or temporary accommodation is secured. Shouldn't the housing officer have done an assessment and be able to give advice to the temporary accommodation team at least, for example, on location? If somebody receives ongoing medical treatments and he has supporting documents from doctors saying he needs to live in the borough to continue access to treatment. So yeah, I mean, yes, the answer is yes. Someone in the council, whether they're in the housing options team or the temporary accommodation team, technically it doesn't matter. The council just has a duty to do it, but they need to have done a proper assessment. I watched a video this week which Will recommended from Doughty Street Chambers. So if you want to know about this stuff, Doughty Street Chambers YouTube channel is as good a place as you're ever going to find anything. They are the best barristers in the country, pretty much around housing. No disrespect to Garden Court Chambers, who are also exceptionally good. But basically, there was a video about kind of recent case law update, and there was a lot of talk about suitability and effectively looking at how assessments are done. My takeaway from that, and I guess Will and Karis, you probably will differ from me, is that it felt to me like the direction of travelling case law was good, but best if you're a solicitor, because you have to end up making quite intricate arguments rather than it kind of being someone like me who's just a layperson who can kind of just sort of walk in and grasp the issues at hand. So, but yeah, I think this kind of issue would be raised in that video if you want to watch it. I think it was like an hour and a half long or something. It wasn't ridiculous. But yeah, in effect, a solicitor would very easily be able to challenge the council simply because an assessment hasn't actually been done. So even it might be the council is actually right, but they got there the wrong way, in which case it could be challenged. I think, and Will and Karis will probably be able to chip in here. If you were to challenge the council, I think initially what they then do is make an assessment. So they could probably still end up with the same conclusion, even if they just kind of went through did a paper exercise on it. But yeah, they should be making assessments. So when you first make a homeless application, the first things the council really want to know is, once they've established if they owe the interim accommodation duties, whether the relief duty is actually going to be owed as it. Well, let me say that again. Whether you're actually homeless, whether you're actually eligible, if those two criteria are met, they need to carry out an assessment of your needs, and part of that assessment is going to be what is going to be suitable accommodation that you're then going to move into. But Will and Karis, do you want to add into that? Because I think there is probably more to say based on the Doughty Street Chambers video, if nothing else. But again, to be honest, quite a lot of it went over my head. I was just painting at the time, so yeah, I was just going to concentrate on the job.
Yeah, I could add a bit, but before I do, Mike, I should. It's somebody's raised it on the comments, and Chigadon has raised it. I think you've got a problem with. Unless, can anyone hear? Is my audio going up and down as well? Because
No,
your
your audio
is,
is fine. Yeah, Mike, you're fading
yeah,
in
but
and
it
out.
sounds like the microphone is sort of swinging close to you and then far away from you. Um,
And you sound fine.
do I? Okay, good. Thank you. That's good.
Can I just do an audio check real quick? Is that better? Can you hear me? Or hold on a second.
Well, it fluctuates, so we might be getting you on a good moment, but
Hold on.
we'll let you know
I
if
had this
it.
problem with the training today, which is weird. Yeah, keep talking, Will. I'll try and sort this out whilst you.
Okay.
And that's the same, yeah.
So just to go back to the Section 189A assessment duty, which is one of my favourite subjects in housing law at the moment and has been for a while. I think it still has a sort of revolutionary impact, and if it can be used to say that the councils now have to be actively looking to help people rather than just looking for excuses not to help people and then giving them whatever they've got without considering their needs once they've accepted a duty, which is the traditional model. Before the 2017 Act came in, they'd just be looking for an excuse to say they don't need to accept a duty. And then if they do, they go, oh, all right then. But it was easier when they had council housing stock because they could just give you a council place. And so the big fight was always about what your entitlement was or whether they could refuse you a duty. But now that they actually have to consider what's suitable for you, it really is important they assess your needs. And where they don't do that, I think you've got a good grounds for challenging suitability, not just because they didn't do an assessment, but the fact that you can say, look, this is all the stuff you would have found out if you'd done an assessment. So I think there's a lot of scope there for challenges. And I thought the Doughty Street video was so. Well, I was at the Doughty Street meeting when the video was made, but I'm going to watch the video again because it was so good that I need to go through it again and then read the stuff that their cases again that they're talking about. So yeah, very, very important.
Cool. Quickly, just is my microphone sounding better now? Is that?
Yes.
Yeah,
Yeah.
cool. I have no idea what the issue is, but yeah. Yeah, as I say, yeah, it just sounds like there's a lot of stuff to get from that Doughty Street video. I just have a feeling, yeah, in the real world, it's just very difficult to, yeah, but you will need a solicitor to actually get the council to follow that stuff because they're not doing it most of the time. But yeah, again, I'm hoping within that the answer that we just gave there's some information which will be useful. But the short answer from this question is yes, someone needs to have done an assessment. Otherwise, they have no way of knowing what's going to be suitable. Just a question very quickly on the live stream as well. Just saying, how do you comment and interact on the Facebook page, please? So there we have a page and a group attached to it. So the page itself is called Homelessness Best Practice CIC, and then the group is just called Homelessness Best Practice. I let people in all the time, but you need to make out like you're a professional. And that what I mean by that is to say, if you don't go in there and just ask questions about your own situation, you basically pretend like you've got a client. Again, it's about minimizing the amount of data you've got to share. So if you join the group, I'll basically see you and let you in. So yeah, cool. Again, hopefully we've kind of dealt with that question adequately. So there's one more question from the week, and then we'll get into the live stream chat. So here we come. Number 3. So if a tenant has received a Section 21, inform the council via email about this, has been assigned a housing officer, and then negotiate themselves with the landlord to be able to stay for a bit longer if they haven't found a place in the private renting market. Would this make it easier for the council to find a flat either in the private market or social? If the council, for example, negotiates with the landlord again and the landlord says it's fine for a couple more months, wouldn't they then not just say, you're no longer homeless, see ya? Just wondering. One would think that if the landlord is cooperating, then it would be so much easier and cheaper for the council to get people rehoused. So I love the logic here. The logic's great. Yes, there is a lot of benefits that would be had if the council were to work proactively, but I think really the person probably knows the answer here, because in effect what they've suggested here is probably what's going to happen. So if you were to get the landlord to extend your, the amount of time you can stay there, essentially what's going to happen with most councils, but not necessarily all councils, is they'll just basically drop you down their to-do list. They'll basically be like, okay, it's cool, we'll worry about this guy in 2 months' time when the landlord actually is serious about evicting again. So that it's for that reason, although it might seem like it makes sense to kind of actually do that work, and it's really good this person's doing the work, actually I don't know if it really helps them get help by the council. So unless you've got a reasonable prospect of finding your own private rented accommodation, I'm not entirely sure whether it's worth doing, or whether it's just worth taking a bull by the horns and just going through the process with the council. So again, Will or Karis, feel free to chip in if you've got anything more on that question. But yeah, go
Oh
on,
no,
Karis.
sorry. I would say there is a potential there that they deem your situation resolved as well. So it even could go as far as say your situation's resolved and you're no longer at risk of homelessness now.
Yeah.
So
Yeah.
it is worth keep chasing and keep on top of.
Yeah.
And when you're coming up to that end of that renegotiated time, getting in touch with the council and keep in touch with the local authority.
Yeah. It's a little bit like when people say, well, if rather than move into interim accommodation or emergency accommodation, what if I just stayed with my family on their sofa? In theory, that sounds great, and that sounds like the council's winning. But in reality, often what happens is the council just forget about you because they're not paying for you right then, and so you kind of, as I say, you have this kind of perverse situation where actually it just delays everything for you, even though actually you're being genuinely helpful. So let's get into the live chat, see how we're getting on. So it's like a multi-part here. So again, guys, if you've got longer questions, I mean, you're fine doing it in the live stream chat as long as it's anonymized. But if you put the question onto any comment on any video on this channel, I will get a notification. Just try not to do it at like 7:15 p.m. on the Thursday, because I might not see it. So let's just make sure it's all there before we start into it. So yeah, basically, if you do a comment on a normal video, like not a live video, there's no character limit, so it just becomes a bit more straightforward. Cool. I think that is all of it. So I know somebody who's autistic and suicidal. He's been diagnosed with severe anxiety and depression and is currently with the MINT team. I'm going to guess that's a mental health team, CMHT or some kind. Just bear in mind that different areas will call their mental health teams different things, although generally the crisis team will be called the crisis team. A senior from the MINT team has escalated his case and managed to get in contact with a team called the Reliant Care Services, who are specialists for supported housing and tailored to vulnerable people with autism, mental health challenges, and learning difficulties. The MINT team have verbally told them that the Reliant Care Services have accommodation ready for him to move into, but a social worker needs to complete Care Act assessment first. The individual is capable of doing day-to-day activities and does not need support to complete them. Could it be likely that this housing being offered to him is because of his autism, or is it a form of supported accommodation whereby someone would need to monitor and aid him to carry out daily tasks? Additionally, would it be best for him to go down the route with the MINT team to take the housing being offered by Reliant Care Services, or try and be housed by the council themselves? So really good question. I guess I'll try and have a go at answering this question, but it's going to depend on how good the Reliant Care Services really are, because there's a lot of organisations out there who make a lot of money from this sort of thing, and they promise the earth. They say, yeah, this is going to be amazing. We've got all these like really qualified people on site, and they'll help you out of everything. And then when you move in, you just find the only time you actually see them is when they want their rent money from you. So I think that's, I mean, if you have a way of trying to find out what the reputation of that company or that service is, that would be good. Sometimes you'll actually get Google reviews where you can read through what people have said about it. And by the way, if you want to have a little bit of power in the homelessness sector, use Google reviews and just kind of say what you think about organisations, because it does work. Because charities or these sorts of organisations hate bad publicity. So if you've got like a genuine complaint, then and you want to air it, then that's a good way of doing it. So the question here, I guess, if we try and just sort of take it back to the basic legal framework first. So you make a homeless application,
This person is highly likely to be in priority need, but it's never guaranteed. You always have to make the argument. But effectively here, the question would be, is there anything about this person which is likely to be exacerbated by homelessness in a noticeable way that's going to leave them at a risk of harm or additional risk of harm? The answer clearly here would be yes. But as I say, you need to make the argument. But once you've made the application, so the council should offer you interim accommodation. And then in that relief duty period, there's a number of things they can do. One of which is they can try and support you into accommodation, which is likely to remain available for 6 months. And my guess is that this kind of potential option of the Reliant Care Services is what they're thinking here. They're basically wanting to, kind of get you in somewhere that's going to be available for 6 months, so they can just kind of close the application down. Now, in this situation, you could refuse that particular offer of accommodation, but it might have a slight impact on your the main housing duty, in that rather than getting a 12-month assured short hold tenancy in the private rented sector, you would only get a 6-month private tenancy, or a kind of essentially you still get the potential of social housing, although that's never guaranteed anyway. So I think my first kind of, just thinking aloud here, my first response would probably be, it depends what this individual wants. Would they rather be in their own property with a front door and have support staff visiting them, or potentially not even that? That's up to them. If so, they should probably persevere with the homeless application. Or would they actually appreciate, if this Reliant Care Service is actually a pretty good deal, then potentially whether they would they'd prefer that. But I think I would say I would want to speak to someone who's actually going to give an honest opinion, because a lot of professionals that you're going to work with in this setting are going to be trying to steer you towards something which just makes their job easier, as a rather cynical kind of observation. So the housing officer will be trying to say, yeah, this is brilliant, this is amazing, you should go for it. The mental health team might be saying something similar, because it kind of means that they can monitor you better or something. But I think what I'd hope is that some professional that you've had contact with, you actually trust that she's going to give an honest assessment. And effectively, I think I'd be suspicious of any professional who says this Reliant Care Services is brilliant, or there's nothing wrong with it. There's always going to be pros and cons. So I'd just be kind of wanting to focus in on what those cons might be, and just kind of weigh that up then against the pros and cons of potentially going down the homeless application route further, knowing that you might end up in pretty scummy private rented accommodation or social housing. We're not quite sure where it is. So I guess there's also a little bit of wisdom here in terms of a bird in hand might be worth two in the bush. And then finally, the last thing I would say is also check out what the move on regime is for this Reliant Care Services. Is it something where people just kind of, just stay there forever? Is there a move on process where actually that would open up options into the social housing sector that are specifically written down in a policy, not just kind of like, sort of, empty words that are said to you? So I'd also be looking at that in terms of, so how long you live there. If you hate it, what's your options? If you hate it and you leave there, are you going to be found intentionally homeless? All of those kind of things might be stuff you want to consider as well. So I appreciate that's an awful lot. I would really hope that someone in the Mint team or someone somewhere has a good relationship with this person and actually can talk them through what the kind of different options might look like, and essentially give, again, another red flag is when they're rushing you, saying, oh, if you don't accept this now, we're gonna not only duty to you. Then that's immediately a red flag, and just you're absolutely legitimate to say, I need some time to take this in, particularly given the circumstances here involving autism and just high levels of anxiety and depression. So that's my answer. Will and Karis, if you want to add anything, go for it. But I'm hoping that kind of gives some answers anyway. Karis?
Sorry, I would just mention the reasonable adjustments that need to be made for your appointments, for your needs and to be met, to be able to continue an appointment. Ask for breaks if you need them, if they're going on too long, or if you're feeling pressured, just refer back to reasonable adjustments to be made in your case.
Yeah, cool.
I would just add, this afternoon, I've spent quite a lot of the afternoon talking to people who had refused offers of accommodation, not in situations directly like this, but nevertheless, they'd refused offers of accommodation and come to deeply regret it because they were found to be council discharged their duties. One of them has been found intentionally homeless. And I'm having to advise both of them about Section 190, which is the duty owed to intentionally homeless people. So Their response, well, the response in both cases really is that I never realised that making one mistake of turning down an offer of accommodation would have such terrible consequences. And one of the problems with any offers of accommodation is that they're usually sort of shrouded in mystery. You get a phone call from somebody saying, "Oh, we found you a property, and you've got to take it," and often you can't even view it. So my advice is always accept it unless it's so awful that you couldn't ever move in there. For instance, you went in there and there was water pouring down the stairs or something. I know that sounds terrible, but the point is, if it is as bad as you think it is, you can always challenge it either by a suitability challenge or by saying you're still homeless. But what the problem is, if it turns out that it was all right and you failed to accept it, you could regret it. I mean, it seems in this case that wouldn't be the case because although we just don't know, it could be that in the background somebody's processed a homelessness application and this is actually temporary accommodation. We just don't know. So it's best if in doubt, or I'd go further than if in doubt, I'd say unless certain that you could never live there, take it and then get your bearings once you're there and protect your position and challenge it after that.
Yeah, that's helpful. I mean, another thing that you could probably do is basically, particularly given the issues involved here, but it would be true even if things like autism and depression weren't involved, would be to basically essentially try and make the housing officer write down the implications of refusing an offer, so that at least then you have a 90% clear understanding. I mean, I've worked with housing officers who would still basically like fudge it and kind of say, oh, this is your own option, when actually it's not. But I think kind of just going back to what Will said there, I think that's probably the safe option. I would just hope that somewhere in this system, and the Mint team or wherever else, does actually know what they're talking about and does understand enough about housing to kind of actually explain what all this means and how things like how long is that person going to be there. I'll give an example of an experience I had with a client in Northants where they were going to be owed the main housing duty, that was certain anyway, and they were in relief duty, and essentially at the end of the relief duty they got a call saying, oh, we've got some more temporary accommodation for you, you need to move. And so they kind of essentially did, and it actually turned out it wasn't temporary accommodation at all, it was one of these informal offers, and the council were being naughty and not actually explaining it, which the LGO did actually uphold in the end. But yeah, I think sadly, I guess the other answer is try and find a solicitor or try and find a competent advocate who can actually sit down and actually ask the right questions of the council and look through these different options to see what they mean. Just to kind of, again, it seems like it's quite a fragile sort of question to kind of advise on. To give you another example of a guy I worked with who he was a victim of modern slavery, basically. We knew he was going to be in priority need because of his health issues. And he had a very dodgy housing officer who we knew quite well. And the housing officer said, oh, you've got mental health issues, you need to move into the mental health hostel in Bedford. And I knew that mental health hostel, and I knew that he was going to be owed the main housing duty. So we said, hang on a minute, what's the offer here? What's the process? Why are you offering that? What's the implications of it? And eventually ground them down and got them to say, yeah, actually, this guy could reject that offer and could just basically hold out for social housing. And he got social housing in the end. And part of my kind of argument was, why are you even sharing his data with the mental health hostel without his knowledge? Because that's essentially what had happened. The housing officer was just trying to shoo him off into this supported accommodation to get rid of him, none of which was legit. So that's kind of why I'm sort of like probably being less kind of less certain there than Will, because I have seen situations where holding out and making sure that the person knew what the implications were and then making an informed decision actually kind of worked out quite well. So yeah, but I guess as Will says, to make sure you're on the safe side, I guess accepting an offer is going to be the safe way of doing it. Cool. So next question. Hey, you right, Cheeseface? Nice to have you here. Question 5. Can you still claim to be homeless if you move into a guardianship coming from a past homelessness, sleeping rough, guarding a residential property from squatters? I am not entirely sure what that means. Will or Karis, have you got any ideas there? I'm not quite sure what that might involve.
Yeah, I've got an idea what that involves. I'll put a link in the chat. Should I put it on the Zoom chat or the
So
YouTube?
put it in the Zoom chat and I'll pass it on because I think you'll get marked as spam. So
Oh, yeah,
yeah.
okay. So here we go. So I won't go into too much detail, but Guardians, um, Guardian properties, it's not people who read the Guardian. Sorry, it's there was a practice that sprung up about 5 or 10 years ago of taking empty office blocks and things which were likely to be squatted, and then organizations would take a lease or a short-term lease from the owner and then divide it up into sort of living units and then rent it out to people. And those tenants were known as guardians because they were sort of guarding the property against it getting squatted, or the whole process was a guard against it getting squatted. And there was a string of legal actions about what the status of the guardian tenants were, because the landlords wanted to get them out. Part of the deal was that when the owner wanted the property back, they would get it at short notice. And you can imagine if you've got a whole building full of residential tenants, you'd have to issue possession proceedings against all of them. It could take a very long time. So the argument was that they could just evict them as if they were in a hotel. And I forgot the name of the case, but the long and the short of it is they are treated as licensees and they have very limited security of tenure. Um, so they're largely outside the Protection from Eviction Act. I don't think you need a court order to get them out, or you may do, but it would be a court order where you just say, "This is a guardian. I've served a notice. I want the property. I want them out." There's very little defence. So to go back to the question, I'm not aware of a homelessness case involving somebody who's, say, voluntarily left a guardian place and said, "Well, I'm not home. I'm not intentionally homeless because I could never stay there." And it may be that you can see that a mean-spirited housing officer may say, "Oh, well, they hadn't said you had to leave, so you could have been there for the foreseeable future." Or a kindly-hearted one might say, "Well, it was only ever temporary accommodation which you couldn't continue to occupy." But I suspect, to go back to the question, um, where is it? I've lost the actual question. It says, "Can you?" Where has it gone? What was the
I
actual
put it
word?
in. So I put it in at number 5 on the screen. So I've
Oh,
already
I'm sorry.
copied it
Yeah.
in.
Can you still claim to be homeless if you move into a guardianship coming out of past homelessness sleep rough? I suspect the answer is have a go, but it may be that they would say you're not homeless because you've got this guardian place. But in which case, you would be entitled to be treated as homeless as soon as you got the notice to quit, I think, because although they could then say you need a possession order. So have a go at applying and see what they say. But you might want to find out how long you can stay there for, because if the guardian landlords are saying, "Well, look, you've all got to be out by Christmas and it's October," I think you'd be entitled to apply and say you haven't got, it's not going to be available for you to continue to occupy. But it may be taking the strict reading of the law. It says if unless you've actually got something that says you've got to leave, and that would probably be a court order, you may not be able to be homeless. You wouldn't be homeless simply because you're living in a guardian property, I don't think. So I hope that helps.
Yeah, that's interesting. Yeah, Karis?
I was going to say, just check the agreement you made or the company, because sometimes they're run by a company, look after the property, and they're given guardianships to people. So check with the company or any paperwork that you were given when you entered the property, because it's like licensees. Yeah, I was going to say the same.
Cool. Nice one. Right, that's every day's a school day. I'd never heard of that before. Cool. So just to say that someone in the chat have just deleted their question. The question was fine, but it's just kind of in the first person. I've also just put like a limit on new questions from this point. So, but the person I've just deleted their comments. If you want to put the question in, I'll get back to you. So sorry, I need to just pin that comment from the start sheet. But basically, you can ask any question you want as long as it's not on your own situation, and that doesn't mean so you can't be. You just need to kind of sort of hide the fact that that's the case. I hope that made sense what I just said. So next question. hi, a client has just been given unsatisfactory stage 2 complaint response. They have submitted an ombudsman case, I guess, complaint. 56-day relief duty over a week ago, still no main duty. Client is clear priority. Okay, so in itself, the fact that the stage 2 complaint is not satisfactory is not surprising. Councils often just basically hope that you're going to give up and not go to the LGSCO, the ombudsman, that is. However, in this situation, the ombudsman would have limited scope to make a comment about priority need decisions, because it's really difficult to explain, and partly because there's some inconsistency. But basically, the local government and social care ombudsman are essentially looking at, did the council, follow the right process, rather than did they make the right decision. And I know that might seem like ridiculous, but that's the way it works. So if you're basically saying, I'm in priority need, I'm obviously in priority needs, and the priority need decision's wrong, then the ombudsman will simply say you should have gone to court to appeal it, or you should have used initially the section 202 review process, which anyone can do. Whereas the delay here, so the fact that there's a delay now, that would be something which the ombudsman would potentially make a comment about. However, if you're not in priority needs, then I guess the council could technically say, well, we're exercising our discretion to roll the relief duty and extend it, so we can actually try and house you. So if the issue is that the council is saying you're not in priority needs, then you need to challenge, essentially. And I guess in this situation, this is where the HRA just breaks down, in my opinion. It might sound like it's a bit of a cop-out from me, because the way the relief duty runs, they're not able to make a positive priority need decision with it until the relief duty is over, until day 57. Weirdly, though, if they've got you in interim accommodation because there's reasons to believe that you might be in priority need, and then they find out that you're actually not, they can issue a negative decision within the 56-day relief period. But what I'm just maybe thinking aloud here, what I'm thinking actually what might have happened here is that this person's clearly in priority need and they haven't even offered interim accommodation, as in they've said, oh, there's no reason to think he even might be in priority needs. I'm assuming it's a he here. In which case, the ombudsman again might actually have something to say about it, because the ombudsman would make a comment about, did the council engage with the interim accommodation duty when they should have? So, I don't know if I can be any more helpful than that without knowing that. So I guess my question for that person is, and again, you can put it into the comments, is was the client initially housed in interim accommodation or not? If they weren't, then I guess really, in one sense, you actually need a solicitor to go and potentially get that lack of provision of interim accommodation kind of taken to court, because again, it's another kind of failing of the way the law works. Oh man, this is so annoyingly complicated. So if you approach a council and you might be that you've clearly, might be you've got like, one arm and one leg or something. So clearly got some impairments going on that might lead to a decision you're in priority need. But if the council are absolutely perverse and they say, nope, we don't even have any reason to think you might be in priority need, at that point in time, you cannot challenge it yourself. You need to go to court, and therefore you're going to need a solicitor. Whereas if they actually issue a decision to say you're not in priority need, then you can challenge that decision itself, like without having to need a solicitor, because you can use the section 202 process, which will be explained in the letter. I hope this isn't going over your heads, because it is this complicated. I can't say it any kind of more simply, I think. So I guess, I'm just going to see if that person is just added in there. Bearing in mind there's a bit of a lag here. So if that person just wants to confirm whether the client was ever offered interim accommodation, because that might help me just give a better answer than what I just did. That was quite a lot of waffle. In the meantime, Will and Karis, can you shed any light on this at all, or kind of see things differently from me? I think we need to know whether there was ever an offer of interim accommodation. So we're going to wait for that. We'll come back to question 6 if we need to. Hang on a minute. There's a bit more. Hold on. There's a bit more to it. So, right. Okay, so I'm assuming this is all about the same client. So, still no main duty. Client is clear priority. Council may deny due to intentionality because of rent arrears, but client was unable to work due to health, thus the rent arrears. Many lies of maladministration. What can client expect? So again, if the council was to issue a decision that this person is intentionally homeless, then you would challenge it at that point and say, well, actually, the rent arrears arose from the unaffordability of the property, and therefore you would not be intentionally homeless. So again, that would actually be quite straightforward from a legal point of view. It's just write a letter basically saying, you know, this decision's wrong and the reasons for it. And then you've got an additional issue here about client in unsuitable temporary accommodation. So yeah, I mean, you've got three issues, one of which is simple. The intentional homelessness decision is actually relatively simple, but the unsuitable temporary accommodation and the council ignoring the medical letter is actually something that the LGO would be able to investigate, interestingly. But this issue of this kind of, still no decision on the main duty and this kind of limbo, that is something I think you would need a solicitor to actually kind of, threaten legal action to get the council to issue a decision one way or the other. So I'm just going to see if there's anything else, just kind of clarifying that further. Okay, there is a bit more. So client also has false information on the case file after data subject access request. The council has apologised and corrected. Client worried that this information was used by the Housing Options Board to deny social housing. So essentially with the subject access request, you should be able to see everything. So if there was a discussion between the Housing Options team and the social housing team, that basically should be discoverable within the subject access request. If there is nothing in the subject access request documents that you received, that's either because the council didn't provide it and they should have, or it doesn't exist. So you could go back to the council and say, what can you confirm there's no data shared with the social housing team, or whatever the name of the team is, and just to kind of follow that up and just see what was shared with them, and you can essentially check that the information at the social housing team is correct. Maybe the quickest way to do that would be through a complaint, through a separate complaint potentially, just because then you actually raise the issue and deal with it. Just going to double check there's not any more to this. Doesn't look like it yet. Oh yeah, okay. So still not sure from this whether the person was ever offered interim accommodation. So without that information, I don't know if I can say any more about this one. But as I say, if anything more does come up, I'll stick it in the. We'll come back to this one basically. So this, I think this question is a reiteration of the question before. I don't know if this changes the question really. So if we go back to number 5, can you still claim to be homeless, make a homeless application to get on social housing register if you move from sleeping rough on the streets for a prolonged time to signing a property guardianship? I think in one sense we've already covered that. So essentially, it sounds as though from what Will and Karis have said is that you've got a license to stay there. You could try and make a homeless application. And there's nothing to lose by doing that, but they might say you have someone with a legal right to occupy, therefore you're not homeless. So as I say, I'm not sure. So it might not be. There's a bit more as well. So it might not be a tenancy agreement, but you can still not be homeless if you've got a license agreement. In situations like this, same would be true for like supported accommodation or something. So it's now, I don't know if it's my connection's not good or something. It's been a bit weird, but anyway, let's just keep going. So related to question 1, what if housing officer says relief duty starts only after a physical copy of possession order received by post, even if date of possession order is already passed, but no paper copy arrived from court yet? So if we just go back to question 1, it's a good question. In fact, let me stick it back up with question 1. Let's do it like that. So the relief duty starts once the council is satisfied that you are homeless. Now, that does not necessarily mean they need a physical copy of any paperwork to be satisfied that you're homeless. They're not having to prove beyond a reasonable doubt that you're homeless. They just need to be satisfied on the balanced probabilities that you're homeless. So if you said you're homeless and you've probably got a bit of paperwork already to kind of back that up, then the council should not be waiting until they receive, that's just like that's just them being really unhelpful and delaying things. And the question of, going back to this kind of idea of at what point do you actually become homeless and the relief duty actually kicks in. In most cases, it will be the day after the Section 21 expires. So it shouldn't really be getting as far as the possession order kind of happening and all that sort of stuff. If you want to know more about that, check out the video on the channel, which is called something, do I need to wait until the bailiffs come or something like that? If you just search for the word bailiffs on this channel, you'll find a video which will go through it and kind of explain that in more detail. But that would be my answer to that. Again, Will and Karis, you got anything to add to it? I think Will might do.
Sorry,
You're on.
I would say I was just looking at the code of guidance about this, and this being the relief duty, because there is a problem that a lot of people complain of or mention of councils deciding, and I've had this but with other things, but the councils decide to accept a relief duty ages after you apply because they just got round to looking at your file. But the question really should be, I mean, in reality, they should say we accept the relief duty from the date when you applied, because unless you become eligible in homelessness during that time, that's when it should apply. But it only applies when they accept it. But then the code of guidance says the duty applies when the housing authority is satisfied the applicant is both homeless and eligible for assistance, which is almost the same, but not quite the same as the Section 188 duty, which says that the duty applies when the council have reason to believe. So I would have thought that if people are unhappy and they want temporary accommodation and they want their case moving forward, presumably they're going to want temporary accommodation. Now, if the council's given them temporary accommodation, they could say we've got reason to believe that you're homeless and eligible, but we're not satisfied of it yet, so we're not accepting relief duty yet. In which case, I would make a complaint at that stage and say this is ridiculous. We've given them reason to believe this. All they've got to do is say whether they believe it or not, in order for the relief duty to kick in. And it's just bad management or bad administration, isn't it, to say we've got reason to believe it, but we're not going to take the next step, which is to accept that that is the same thing. So if you go to the council website and search for housing complaints, or do a Google search for the council in question and then housing and complaints, I would put a complaint in and say, I applied to the council on X date. I think that since then the council have had every reason to be satisfied that I'm homeless and eligible, and so the relief duty should have been accepted. The only reason I think they're not satisfied of it is they haven't bothered to look at the facts yet, and so I'd like somebody to get them to do that. And then usually, I mean, I made a complaint the other day about Lewisham, and they hadn't responded to correspondence from me for about 3 or 4 weeks. And I got a message back within 4 days saying, we think we understand your complaint. We'll get back to you by 6th of February. So at least you get the feeling that things are moving forward if you make the complaint. It may not be instant justice or whatever, but you're not going to be in that limbo which you can be in for ages, where you're waiting and you're told the housing officer will get back to you in sort of soon, and then another 2 weeks goes by. So I'd make a complaint as soon as you've made the application if they don't accept a relief duty within, say, a week or something.
Yeah, I think that's a really good way of doing it. I'm going to say something which I think might end up being so convoluted that it doesn't actually make sense. But in a situation where the council is in this situation where they're denying to accept the relief duty when they should do, if when you finally get the complaint upheld, which could be a couple of months down the line or something, at that point, effectively, what the council would have to do is immediately backdate, kind of basically try and make it as if they didn't make the mistake in the first place. So they have to backdate your relief duty start date. And effectively, what that might well then do is basically skip to the end of the relief duty if you're in priority need, not intentionally homeless. And so actually, you might end up weirdly in a kind of a slightly better situation where they don't try and offer you these lesser housing options in the relief duty, because they're going to have to skip right to the end of it. Because this is something the LGO would get involved in, say, essentially, by delaying the relief duty, they've deprived this person of an opportunity to get housed, or, delayed their opportunity to get housed. And so in effect, you actually might end up in a slightly better situation, although that's so kind of technical and obscure that I don't aim for that outcome, but I think that actually might be a little bit of a positive that would come out of this situation. So if you complain, that hopefully just kind of G up the council to actually get on it and hopefully make a decision. And as I say, if the main duty is owed, then actually that might be a better situation to be in, because what you're effectively doing is you're erasing the relief duty when they're going to try and offer you lesser types of housing options. As I say, I don't know if that made sense or not, because it is just it's so ridiculous. The more I look at all this stuff, the more ridiculous it gets. Housing officers don't understand it either, by the way, so it's not, it's pretty record. Cool. So, just so the clarification to our question 6. and that is that that basically they were offered interim accommodation. So let's just go back and look at this with this kind of information. So client just been given unsatisfactory stage 2 complaint response. They have submitted ombudsman. 56-day relief duty was over a week ago. Still no main duty. The client is clear priority. Okay, yep. Client may deny due to intentionality because of rent arrears. Okay, so effectively, if you were offered interim accommodation, then I'm going to guess you're still in interim accommodation. That must be the only logical way of reading this. And therefore, yeah, if the 56-day relief duty period has ended, it's in your interest to try and, you know, basically make a fuss until they end it themselves, until they actually get, you know, kind of get up to speed. So, yeah. The little comment there about so many lies and maladministration, when it comes to running the complaint through, try and just bullet point everything, and just bear in mind that there'll be certain things that the council might have done. They might have lied about stuff, but try not, although that might be really annoying, just try not to get too bogged down with the relatively less important things. I know that sounds terrible to say, but focus on the timing, focus on the black and white stuff, you know, the date the relief duty should have been ended, you know, the decision that should have been made, focus on that stuff. In my experience of kind of going down those kind of rabbit holes of, you know, this housing officer said a lie at this point just doesn't really end very well many times. So where are we up to? Hey, right, Matt. Gosh, a lot of questions happened very quickly. So we've done that one. We've done that one. Done that one. Yeah, I've added that one in. Okay, I think this is the next question, and there might be some couple of bits to it. Someone is deemed non-priority, and the only help the council is offering is a room in a private rented accommodation. If the person moves into a private rented accommodation temporarily to get off the streets, can the individual make a homeless application later on down the line to get onto the housing register and try to get a council house? Not if the kind of the shared accommodation is deemed to be suitable, which it probably will be. The council will say that it is, even if it's not. So essentially, yeah, once you accept some kind of, you know, sort of settled accommodation, effectively any homeless application will come to an end because you're deemed to be no longer homeless, and you're not about to be homeless anytime soon. So if you were to become homeless again down the line, you just have to make a fresh application. So yeah, I mean, this is why it's so such a delicate, you know, kind of decision to make, because, you know, yeah, you can basically accept the accommodation and it turns out that it's not what it was, you know, what you thought it'd be, and you can end up kind of really regretting it. But as Will said earlier, the safest option is to accept it because it's better than nothing. And yeah, and other than that, I don't know what to add to that. That's just the state of the, you know, the country at the moment, really, particularly in London, but not just in London, that you kind of have to deal with that stuff. So Matt's just asked, can you do a session on short video on leasehold, Landlords and Tenants Act? I can't, but Will can. So I don't know anything about it basically, but yeah, no. So it sounds like a very reasonable question. The issue would be whether it might be something Will could do as part of his live stream on a Monday or something, or, you know, something around that. I don't know how much prep you need to do, Will. How up to speed are you with the Landlord and Tenant Act?
I'm very rusty on that indeed. I mean, I haven't studied leasehold stuff since I was at law school, and I don't tend to deal with it much in my work, because it's a slightly different area of work. There are lawyers who specialize in it. All I can, I mean, I don't think I could do a sort of a guide to leasehold stuff because I simply don't know it. I'd be like writing a guide to admiralty law or something. But if anyone's got any specific questions about leasehold, I'd be happy to look into it and answer them. And I can point you in the direction of people. I know that Giles Peaker of Nearly Legal is more of an expert on leasehold because he does stuff in leasehold tribunal, you know, the tribunals where there's disputes about leasehold. So I'm afraid I can't really help with that.
Yeah, I mean, I've got to say, whenever I see a post on Giles' blog where he's talking about the stuff, I just switch off. I've got no idea what this is talking about.
Yeah,
yeah.
I was going to say it's quite technical and it's different to, well, like we said, what the leasehold and landlord and tenant act are kind of two different things as well. So if you have a leasehold, it's going to be quite technical, and a lot of things, regulations have come in, especially after Grenfell, I think it was, with the fire safety and who charges the leasehold or the freehold for little service charges, what they cover and things like that. So it's really technical. So that could be like a huge 24-hour video, a whole or 6-month course if you really wanted to break it down.
Yeah, I can think of nothing less interesting, to be honest, but I appreciate if you're actually involved in it in yourself. I'm sure it is very interesting. Okay, cool. So have I missed a bit of this question? Looks like I've actually missed a couple of questions from before as well. So let me come back to them. So yeah, so is an email contact address sufficient? The options officer has asked for a chat with a member about the person wanting to move to the options officer's area. So at some point you are going to have to speak to him on the phone. That's just kind of, yeah, I mean, as much as you should try and avoid it, because yeah, it's a legal process, and you kind of, you're sort of very exposed if you're having a phone conversation with someone you never met before. They are gonna want to have a face-to-face or a verbal conversation with you, because they need to go through the kind of, a lot of details. So certainly an email contact address in the first instance when you first make the application is going to be valid, but they will, as I say, they'll want more from you at some point, and that is reasonable for them to do. They need to, kind of actually go through quite a lot of information at some point. So yeah, I don't know if that. I'm hoping that's the question that you're actually asking there. Okay, I'm just going to go back and follow up this question that we missed before. So is someone entitled to extra bedroom in Hillingdon if child is on DLA middle rate? If so, how do they let the housing officer know? I don't know the answer to that. The only way you're going to find the answer to that is if you Google Hillingdon plus the term housing allocation scheme, and you'll get their policy on how, what entitles you to different bedroom sizes or whatever. And so the only way you're going to be able to kind of to counsel on that is if you can find something in their own policy which basically says that they haven't considered the facts properly, and therefore you can kind of put a challenge in. And the housing allocation scheme should also tell you how to challenge a decision, or how to challenge the priority revenue. I feel like I've also might have missed some other questions as well, come to think of it. So I'm just going to just scan back for a second. So I'm really sorry about this. Yeah, I've not done a good job here at all. I don't know how I've missed all these. So next question. Good evening. Person received Section 21. Housing officer assigned. No PHP yet done. 1 month left until Section 21 expires. Finds a place expensive but manageable. Should they take it or better wait? So I think yeah, going back to what kind of Will was saying earlier, if it's manageable, then take it. I think yeah, there's just so many uncertainties in the application process, and there's every chance that you end up somewhere worse than you would do. So I think if you can find something which is workable, that you can afford it, then you can always go back to the council and say, look, I found this property, can you help out? This person isn't owed the relief duty yet by the look of it, because the Section 21 hasn't expired, but they are owed the prevention duty, and so an assessment and PHP should still have been done. So yeah, but I think to be honest, if you have the ability to not rely on a council, then don't rely on a council, because it's just, even at the best case scenario, it's just stressful and prolonged, and I'm not sure that the benefits of kind of hanging on for the chance of social housing is worth that amount of stress. So because you can always end up with private rented anyway. So I think, yeah, if you can find something that works, take it. That's, yeah, my kind of thought on it. Obviously not legal advice or whatever, but yeah. And then again, I don't know how I managed to do this, but I've missed loads. So 12, how would someone be considered as high priority based on non-physical domestic violence due to his mental health that leads him to become homeless by his family member? Okay, so there's two different processes which would potentially be relevant here. One is the Part 7 homeless application route, and the second is the Part 6 housing register application route that will follow on from the homeless application. And within the Part 7 route, as in part 7, then there's no kind of grading of priority need. You're either in priority need or you're not. If you're homeless because of domestic abuse, doesn't need to be yeah, I mean, that's why we call it domestic abuse rather than domestic violence now, because there's no need for it to involve physical violence. It could be emotional, financial, sexual abuse, so-called honor-based abuse, all that sort of stuff. So in one sense, if you pass that test, if it is unreasonable to continue to occupy your accommodation because of a risk of domestic abuse, or you've actually already fled, then you are already you're already in priority needs, but there's no additional priority at that stage. But then when you get onto the housing register, where councils have their own policy, there are some councils that would give you additional kind of priority as a survivor of domestic abuse, but most don't. Most would just kind of class you as someone owed the main housing duty, and kind of lump you all together. So I'm hoping that just made sense in terms of what I said. So yeah, and just to kind of reiterate the usual sort of stuff, there is no requirement that you have police evidence to prove that. The local government and social care ombudsman make it clear that the council's default position should be to believe people who disclose they've been abused. So yeah, if the council starts saying, well, without a police crime reference number, we're not going to do anything, that's maladministration. That's going to cause some injustice there. Right. Wow, this chat is sending me all over the place. Carison, will let me know if you've got anything to add to that, by the way. Let me just try and find our place. So I think this is the next question. Again, if I've missed something, guys, just please, apologise. Just write it in again. If you ask a question again that you've already asked, I'll obviously answer it this week. Yeah, as long as it's before that cut off. So can a council lower a family priority from the housing register stating that they aren't homeless because they have suitable property for 6 months despite a Section 21 has expired and the family waiting? Yeah, if that's the case, then it's not true that they have suitable property available for 6 months if the Section 21's expired, because that they should already be treated as homeless at that point, really. Unless the landlord has said, oh, don't worry, I'm going to rescind the notice and kind of cancel it, which doesn't sound to be the case here. In terms of what you do about that, I'd probably start by just emailing the housing officer and saying, I'm looking, so essentially, let me just go to the code of guidance just to show you what we're talking about. So if you Google homelessness code of guidance, and go to paragraph 6.35. So this is the PDF that you just Google. Let's go to 6.35. You'd essentially just kind of, you'd basically just quote this bit here. And this is just the bit we're talking about today. We've already mentioned it a few times, where we're saying once the Section 21 expires. So basically, if these 3 criteria apply to you, and we say this every week because it obviously affects a lot of people, so it's worth reiterating. If these 3 criteria apply, so the notice, the Section 21 is valid, and the landlord is not going to be persuaded to keep you on, and there would be no defence to an application for possession order, which there probably wouldn't be, then it is unlikely to be reasonable to continue to occupy. This terminology here, reasonable for the applicant to continue to occupy, is code for you are already homeless. If you have accommodation but it's not reasonable to continue to occupy, you're homeless under Section 175 of the Housing Act. So if that's all the case, then you have not got accommodation which is going to be reasonable to or available for the next 6 months, because at some point the landlord will get to the to the bailiff stage. But if you read through these paragraphs here, so 6.35 to 6.38, it makes it very clear that council should not be advising people to wait anything really past the expiry of the Section 21, except where these 3 criteria don't all apply. So Will or Karis, would anything to that one? Oh, hang on a minute, there's another line to it as well, but it doesn't change what we're saying. So let's get the questions back up. Here we go. So yeah, so there's a bit more as well. So yeah, I mean, they shouldn't have. The council made this decision and closed the homeless application and lowered the priority banning when the applicant mentioned that the review will be asked for. Yeah, I don't know. You guys got anything to add to that? I think what I've just said will kind of give you some pointers in terms of how to deal with it.
Yeah, I mean, it's difficult to know why they did those things, although it may be connected with the thing that the review was asked for. If you see
Yeah.
what I mean. They may have decided they didn't owe a duty. Somebody asked for a review and they said, oh, well, we're closing our file, but they may have been, that's what they, hopefully the review will resolve that.
Yeah. Yeah, I mean, as I say, I'd be just writing to the housing officer, just quoting those paragraphs as well, just to kind of like prompt them to actually look at what the law says, because many housing officers actually don't know what the law is. They're just basically doing what they're told. So where are we up to? Right, okay. I don't like the look of this question, but might someone get into trouble if they hide from the council that they've moved into guardianship? Yes, yes. You need to be honest with the council. This would actually potentially be a criminal offence, basically. And if you ask people like us, what should you do? We're always going to say the same thing: don't lie to a council. It's fraud, basically. And if they do catch you, then they will. Well, they might throw the book at you. I think I don't know. I think the fine's up to like £5,000 or something. I'm not sure what the penalty actually is, but yeah, I mean, obviously that's not okay. But you know, that's a bit of a silly question, really. Right. So have we got past it? We only got to the cut-off point here. What's going on? Where's the cut-off point gone? Okay, right. So we're actually past the cut-off point, guys. It's past 8:30. I'm going to hang around, but if Will and Karis, you need to go, guys. I know you've had chaotic weeks. Feel free to go. I'm going to try my best with the remaining questions to see if I can get through them. If I don't get through them all, we'll roll them on to next week. So
if I could just say, I probably will go now if that's all right. But I just apologise to anyone who tried to check into my live stream on Monday. There were technical problems and it didn't go ahead, but hopefully it will be going ahead next Monday at 7:30 on the William Flack Law channel. So if you didn't get any questions answered tonight and you want to have a shot at putting them in again, we probably have time. It's a bit quieter on my channel than this one, so we'd probably have time to answer them. And so I'll say goodnight for now and see you guys on Monday.
yeah, thanks, Will. Thanks for your time. Appreciate it. Cool. Yeah, I'll be there on Monday as well, so I'll see them. So yeah, so number 15, bailiffs were mentioned by the host. I'm guessing they're talking about me there. So I've been reading articles on Google News, private landlords, and they're commenting. I think I saw comments that council saying stay put, but a CCJ perhaps be on your record. Yeah, it's one of the many reasons why it's not reasonable to, or it's not appropriate for councils to ask you to stay until the bailiffs come. So again, if you actually go onto, if you go on the YouTube channel, search for the term bailiff, the video will come up, and then in the description there are two LGSCO cases, like links to it at the top of the description. One of them is actually a landlord whose tenant was advised to stay until the bailiff stage, and the landlord actually got compensation, as well as, I'm not sure if the tenant did actually in that case, but the landlord got compensation because council should not be telling people to stay put. Yeah, I mean, there's legal fees. There's potentially, like, you know, kind of if they get legal advice or something, there's additional fees as well. So council should not be saying stay put. The only reason they do is that no one challenges them, and so it's almost become like, you know, this magical thing where the councils just get away with it. But if you challenge it, the LGSCO will uphold the complaint. It's quite an easy one to prove, actually. And as well as getting compensation, you'll also get things like the legal, you know, the court costs recuperated as well. So how are we getting on here? Done that one. Yeah, so be careful of council advice. Yeah, when you get advice from a council, bear in mind you're dealing with a housing officer who's probably never had any training, and they're just regurgitating what they've been told by their colleagues. So so this sort of stuff, as I say, the code of guidance, it might be called guidance, but it's telling councils how to interpret the law. So it's good. It's the council's rule book, basically. It's what they should be doing. So again, guys, if you put questions in the first person, I'm just going to remove them. I know that sounds harsh, but that's just one of the rules of the live stream. So Matt, if you want to just somehow, yeah, maybe go, if you go onto Will's, so if you go on William Flack Law channel on YouTube and just stick that question in about section 20 into into a comment somewhere, he'll get that notification, because it might be that although he said he's a bit ropey on it, it might be he knows section 20 quite well. I don't know. Yes, okay, so this is the sort of thing I was talking about earlier, question 16. No, just try and actually copy it. So someone has ongoing housing registry application since last year, but no response. Person is waiting for main duty decision. Can priority date be backdated, or will it start when put on list? So good question. If you apply to the housing register but you're not homeless, you'll get banded. It might be, your band C or something. Then if you become homeless and you make a homeless application and then they owe you the main duty, it might be they move you up to band B, but they'll move the date that they'll make the band B active from will be the date that they made that decision, which is another reason why you just need to chase people, chase councils for the relief duty to end when it should end. Otherwise, it's just delaying everything. But yeah, so it's not, so your band B would not go back to when you originally applied and were banded as band C, if that makes sense. Does that make sense, Karis? Yeah, I think I'm making sense. So yeah, that's kind of, yeah. So your effective date would be the date they made the decision that you're owed the main duty, and the new banding would then be based on the fact that you're now main housing duty owed. Yeah, Matt, as well. If you go on nearlylegal.co.uk, that's Giles's blog. He's also on LinkedIn if you want to just check him out on LinkedIn. I think there's a whole section about leasehold on his blog, because he basically does an archive where he's got all the different blogs he's done. And I'm pretty sure there is one about leasehold. I might be wrong about that. There's certainly one about homelessness, which is very helpfully divided up. So, okay, again, guys, if you're asking questions in the first person, I'm going to remove them just to preserve your privacy. So this question here, I think, is the next one that I can see. My mate's supported accommodation is closing down on the 31st of March. However, he's going through the review process. Main duty was declined at first stage due to moving into supported accommodation. Is there a bit more to this one? What happens if your supported accommodation is closing down and you're going through review? So I think that's captured it. Okay, so I guess in the first instance, when you're within 56 days of the 31st of March, will be something like the 3rd or 4th of February or something, you should make a homeless application if nothing else has been done. I mean, you'd hope that the council would be aware that your support accommodation is closing down and they've actually kind of been a bit more proactive, but they might not have been. But you can make a homeless application when it's likely you'll become homeless within 56 days. So as I say, if you count back 56 days from the 31st of March, you'll get to like the 2nd or 3rd of Feb. Make an application on there. If you go on this channel and search for the video, the best way to make a homeless application, you'll get a video which kind of lay out the steps you want to take. So write it in email, for example, kind of all the sorts of things you want to include. But until then, the main duty won't kick in. So essentially, unless there is some special local kind of policy they're following, I think you'll just have to make a homeless application as if you were just getting a no-fault eviction or something. And so the usual process would apply of, interim accommodation duty if the duty is owed, relief duty, main sort of duty decision, and then waiting in temporary accommodation if you're owed the main duty until you get housed. I don't think it would be any different just because you're in supported accommodation or have been in supported accommodation. So again, Karis, let me know if you know different from that, but I think it'll just be a case of making a homeless application as anyone else would be. So Karis is nodding, so I'll take that as an affirmation there. Cool. I think there's some chat going on, so I'll just let that keep going. Yeah, just a quick, just for those who are kind of getting annoyed that I'm not answering all the questions. Like if you put a question into a comment on a video on the channel through the week, it just means I can prepare better and I will answer those questions. So or just apologize over. So yeah, and it starts at 7:30 every Thursday. Equally, if you want to show up at 7:30 on Monday on Will's channel, he'll have space to answer questions as well. Cool. And so again, if there's any questions that you think I should have answered that I haven't, just let me know at this point. But other than that, yeah, as Tiff's saying, if you subscribe to the channel, there's a nice little little link there. If you subscribe to the channel, you get notifications of when we're going live. So yeah, I mean, that's one reason to subscribe. Also helps me out as well, which is nice. So, and there's some other stuff. Yeah, I appreciate. I probably need to review how I'm just managing this. So there might be some stuff in the chat that I'm missing as well. There seems to be some just helpful discussion going on between people, which is great. So I let that, as I say, let that keep going. There's a question there about SARS, so subject access request being redacted. So yeah, so when you make a subject access request, if your file includes other people's data, which often they do, because often housing officers will basically send an email about 10 different clients, and you will only see your kind of actual details in there. That doesn't necessarily mean that the council's hiding anything. There's not many situations where they can legitimately hide information from you. If they're getting legal advice, they can legitimately hide it. In Bedford, and I did raise this with them many times, they would redact it by highlighting it in black and saving it as a PDF, which you can just reverse. So I would literally had cases where I could see everything they'd basically been writing there, which actually turned out to be quite helpful because they were saying some things they shouldn't have said. But yeah, so there will be some redactions, but it shouldn't really interfere with your understanding of how your case has been processed. So just someone again, yeah. Again, I just reiterate, because it's quite difficult to follow what are questions for me and what questions are for the chat. If you put questions in the comments and the videos on the channel, I'll definitely know it's what it is. So someone is put in hotel. Does this count as relief period until the personal housing plan comes through? So not necessarily, because there might be a few days delay. So you make an application on the 1st of February. If there is reason to believe that you might be homeless, might be eligible, might be in priority, then they have a duty to provide interim accommodation, which is immediate. That will be the 1st of February. But then it might take them a couple of days to actually make inquiries and be satisfied that you are in fact homeless and eligible, which is the trigger point for the relief duty. So in theory, the interim accommodation duty should come before the relief duty very slightly by a few days. And then you would remain in the interim accommodation as long as there continues to be reasons to believe that you might be homeless, might be eligible, might be in priority need, until the final decision is made at the end of the relief duty. So I'm hoping that answers that question. Where we go, right. So whilst that just right, I'm going to try and unpick the chat a little bit more. So I apologize if I missed things, guys. I'm doing my best there. But what I will do is now go back to the other questions that came in through the week that were not anonymized, because here's the other thing, because they were not anonymized, but they've been put in a video on the channel that's not linked with a name now. So I can now kind of share them in the first person, which is different from the live chat, which if you're wondering why the hell I'm sharing these questions, and because it goes against what I've been saying, because basically there is no yeah, you can't see from here who said it, and so it's not personal data. As soon as you link personal data with your IP address or whatever it is it's called, it's personal data, which is why I'm saying that people need to ask questions in the third person. So question 19, I've been given a section 21 last July 2024. I received an accelerated possession order from the court. I was sent to the accelerated possession order in October and looked at the paperwork. The agent who manages the property and gas safety inspection never happened. No one carried out the inspection, but the certificate states it did. The company who allegedly did the inspection didn't have the full address, and the email address given was the Gmail address with the engineer's name at the beginning. There's no agent address or name of the landlord. I have highlighted this and have a court case in April. The agent is harassing me. Can I claim for this stress? I'm disabled and suffering from mental health disorders and social anxiety. So it sounds like you're actually doing a fantastic job there. It sounds like you've done what you need to do. You've raised the issue, and basically it will all come out in the wash when it gets to court. However, that does not stop this landlord, the fact that the agent is stressing you out. What you could do is effectively make a homeless application now via email and just say, my landlord or the landlord's agent is harassing me. Can you help me out, please? And the council housing officer at that point is very motivated to help out if they've got any sense, because effectively you're delaying you becoming homeless, which is a good thing. And they can effectively write or contact the landlord or landlord's agent and throw the book at them and say, we're going to prosecute you if you keep doing it, because housing officers do have or councils have the power to prosecute landlords who are acting unlawfully. So that's something you could do. And also, potentially it just helps as well, because what the housing officer will also say to you in an email is saying, don't leave the property. And you can then send that on to the landlord and say, look, the council's telling me not to leave yet because, we're nowhere near this point. I mean, I say all that. We're actually well into the eviction process here. So arguably the council should already be involved. but yeah, so but the landlord. No, right. I'm sorry. It's been a long day. I've been training today. The failure to issue the gas safety inspection certificate means that the notice is valid. So if we go back to the code of guidance, the bit we talked about before, this is kind of what it's talking about. So one of the criteria is that the notice is valid, and therefore, although the section 21 has expired in the question that's been asked here, because it's not valid, you're not homeless. Therefore, the council don't actually have to do anything yet, although they can be helpful if they want to be. So this would be an example of, why these three criteria are set up the way they are. No, that one there. And then the next question that came in through the week is.
Sorry, can I add to that one?
Yeah, please do. Yeah.
Sorry, with the harassment from your landlord, try and keep everything in writing. And if they get remotely intimidating, you can call the police or refer it to police, and they'll give you an incident number. And also you can talk to your local authority. The councils have a tenancy relations officer, and they usually help when you make your homeless application. They'll help with dealing with your relations with your landlord, so they can act as an intermediary as well.
Cool. Yeah, that's helpful. Thanks, Karis. Yep. So number 20, the borough I live in won't let you register for council housing unless you've lived there for 3 years. I'm told it's possible to get housed. That might be true in terms of the 3-year residence requirement, but that only applies if you're not homeless. If you're homeless, you have local connection under part 7. If you've lived in settled accommodation there for either 6 out of the last 12 months or 3 out of the last 5 years. Or you've got close family living there for 5 years, or you have an employment contract in the area. So a lot of councils know, and I have done videos about this on the channel. I think there's a video called "Why is local connection so confusing?" and it's partly because they use the same term to mean different things, which is obviously very confusing. So yeah, if you're homeless and you're told, oh, you haven't lived here for 3 years, then they're talking nonsense. That's not the test. They need to apply the Part 7 definition of local connection, which is much more relaxed. And then finally, from the week, so question 21, my 56 days is up on the relief duty. I haven't even got a personalised housing plan in place. My housing officer is not answering calls or emails. The customer services even send her emails on my behalf, but nothing, complete silence. I haven't even received an offer of anything. I'm on the relief duty stage now. I'm on day 46. My application has been passed to the private sector team, I guess, but I've heard nothing from the private sector and nothing from council since. I will say something on day 57. Hopefully I can move on to the main duty. So yeah, yeah, I mean, I'm not sure if there's a question in there. Actually, I think the person's doing the right thing. Essentially, if it was me, I'd stay quiet until day 57 and then complain. Because as I said earlier, what might then happen is the council have to accept that the relief duty's ended and they need to make a final decision. And you skip the whole kind of, final accommodation offer, and you'll effectively get at least a 12-month assured short-hold tenancy rather than 6-month assured short-hold tenancy if you're owed the main duty. And I realise how much jargon I'm saying this tonight. The main duty is the kind of the really good one that is owed to people who are in priority need, not intentionally homeless, and eligible for assistance and local connections taken care of. So that's the thing. That's the best. That's the best outcome if you can get it, but you can't always guarantee getting the main duty. But the main duty decision will be on day 57, or it should be on day 57. So yeah, what I'm going to finally do just to finish up, and Karis, if you need to go, cool. I'm going to actually work from the bottom up just so I can make sure I'm not missing any. So yeah, cool. Thanks, DC. So if someone is forced onto universal credit, can councils kick out tenants if you see rent delayed, please? So no. Basically, in fact, let me get it for you. It's in the code of guidance. It mentions it specifically. I think it's like 9.17. So I mean, well, but let me start again from the. So basically, if you were to be evicted, if the council were to literally evict you, it'd be monumentally stupid, because you would not be intentionally homeless, because the act of remission was non-payment of rent or mortgage costs which arose from financial difficulties which were beyond the applicant's control or the result of housing benefit or universal credit delays. So if the council were to evict you, you wouldn't be intentionally homeless, because it's out of your control. So 9.17 is a good one. It's a very good one, actually. There's other good stuff about it. So what's going on with my screen here? Oh, hang on, I'm not even sharing the screen. uh, let's get the screen up. So yeah, not here we go. So yeah, this should be it. So yeah, 9.17 code of guidance. Google it. This bit here, this is the bit you'd want to just kind of rely on. I think the as I say, I can't believe the council would even try and evict you if it was just a case of universal credit delays, unless you were deliberately not claiming it or something. Karis, do you want to add anything to that one?
Yeah, I was just going to say, so before a council has to take possession proceedings, they have to adhere to what's called the pre-action protocol. And that is to find out if there's anything going on with the benefits. So if it's delayed, you can inform the council, just keep them informed by email. So you've got that paper chain of you did inform them you're now out of work, you're now claiming benefits, universal credit, and they should be helping you claiming housing benefits and working with you to resolve the problem rather than just escalate everything to eviction. Now, sometimes saying that they do sometimes just escalate it to eviction, but this is what they should be doing. And if you have that paper chain of emailing every update from the UC, everything you're doing in terms and of working with the DWT to claim that benefit, just email it to the council, and that they should be acknowledging that. So you've got a paper train of what you have done to keep them informed of the situation, and that you're doing your bit.
Yeah, sounds good. Cool. Is housing first good? Great question. I might do a separate video. Basically, my very short answer to that is yes, it is good. So for those who don't know, housing first is this model that was developed in New York back in like 1990, where essentially people who are homeless are just given accommodation, believe it or not, and actually, believe it or not, that works really well. The problem in this country is that lots of charities say they're housing first when they're not, because there's very strict criteria that make it work. For example, one of the criteria is the accommodation needs to be dispersed across the district, not all in one block. But lots of charities say, yeah, we're housing first. Come to our block of 200 flats, they're all housing first, which is nonsense, and therefore the actual outcomes are nowhere near as good. So if it's true housing first, it's great. If it's not true housing first, it's probably not. Right, so so Tiff's just asking, so Safe can't get kicked out. Are you talking there about the Homelessness Code of Guidance? Yeah, so you are. So sorry, if you Google, so just Google the term Homelessness Code of Guidance, PDF if you want. It will come up. You get the PDF, which is the most recent version of the statutory guidance, and if you go down to paragraph 9.17, you'll find that little excerpt. I mean, that document as a whole is brilliant. It's my kind of go-to document for everything, pretty much. Because it's what the council should basically do, and what the law basically is. Right, I'm sure I've missed some people's questions there. I'm so sorry. If I have, please put them, kind of ask them again on any video on this channel, and I'll get a notification, and I'll then be able to answer it next week. If you found it useful, as always, do give it a like and a share if you can. More than that, if you find this stuff genuinely useful, it would really help if you share it on social media. If you see someone like asking a question about bailiffs or whatever, just stick the video I've done on the channel onto that response, because it just gets people. There's a couple of Facebook groups really pissed me off this week. One's actually pretty good. Housing Advice UK is usually really good. The admin knows what he's talking about and does actually monitor it. I think he just missed a few comments, but essentially someone was asking about, I'm pregnant and I'm homeless, and everyone was like, oh, how dare you get pregnant? It's just not helpful in any way. So if you do see that sort of kind of question being asked, just kind of point them towards the channel, and I think it might be a better way of explaining stuff to people. But yeah, cool. Thanks guys, thanks Karis for your time again. See you on Monday, I guess, if not before. For everyone else, guys, we'll be back on this channel 7:30 next Thursday. If you ask questions in advance on the channel comments, I will get them, and you'll get a better chance of it being answered. Plus, there's not a character limit, so you can kind of take more time over it. And we'll be on Will's live stream on Monday at 7:30. And if you've got questions, you can also ask them then, and you'll get an answer. So, yeah, cool. Take it easy, guys, and we'll see you next week. Oh, hold on. See you later, guys. But there's one final question I've come in. I'm just going to just tackle it now because I might as well. because I'm here. You know, Karis, feel free to go. So my mate is pregnant and has 2 children, one special needs, who is mitochondrial global development delay, immobile, has been offered an accommodation from temporary, however, it's unsuitable. Help. So yeah, we're not in a position to help particularly, but basically, it sounds like there's probably going to be a good argument to be made that it's not suitable, because I doubt that the council's properly considered the child's special needs. So your first kind of the friend's first kind of point of call is probably, I'd imagine children's services are involved in this case if you've got someone with that disability, because my experience is that would be the case, is essentially to get the other professionals involved to write to the housing team and saying, hey, this is not suitable, stop it. If you can get a solicitor, then do. If you go on Will's, so if you go on wflacklaw.com or .co.uk, forgotten, let me find out. So Will on his website has basically got a list of legal aid funded solicitors who can take legal aid basically. So I've actually got it here. Let me just put it into the live stream chat. So kind of do have a look at that list. I'm not sure if Karis, so it sounds like you're at capacity at the moment. So I think Virgo's is probably not worth trying at the moment, but that might change soon. Yeah, then so okay, just a conversation going on. Okay, yeah, so I think that's it, guys. Right. We'll see you next week. Take it easy, and I'm hoping this has been useful. And the number one rule about all this stuff is just keep trying, keep persevering, and people do get good outcomes. So yeah, all the best.